Supreme Court Judge.
Good morning, Your Honor, Anthony Mrima. Wish you the very best.
Thank you, my Lord.
Good morning, Honorable Rotich. Let me also say that I know you because I worked with you when you were our registrar in the Court of Appeal based in Malindi.
Indeed.
Thomas Ichale is my name. Karibu.
Thank you, Honorable Judge of Appeal.
Good morning, Mheshimiwa. You're welcome. My name is Olwande Evelyn.
Thank you, Honorable Commissioner.
Good morning, Dorcas Odwor, Senior Counsel and Attorney General.
Thank you, Honorable Attorney General.
Thank you for the introduction. Honorable Rotich, if you could tell us your county and your ethnicity.
My county is Elgeyo Marakwet County, and I'm a Kalenjin.
Very well. We'll start the interview. We want you to be very comfortable. I don't know whether that seat is comfortable for you.
It is.
It is?
Yeah, thank you.
Yes, just make yourself comfortable, relaxed. Although it's an interview, we like to make it conversational so that we can get the very best out of you. So we want to start by asking you to tell us whether you are judge ready. To be judge ready, you have first of all to describe for us an ideal judge. And when you describe an ideal judge, show us how you fit in that frame by enumerating the achievements you have made in your career, what skills, experience, learnings or innovations that you are going to bring to the High Court. We are struggling with the backlog of cases in the High Court. We know you are a judicial officer, a chief magistrate, so we want to know your case management expertise, because we are looking for people who are absolutely organized, who can manage a docket and manage it well. So if where you have been working is disorganized, then obviously you are not the kind of a candidate we are looking for. We are looking for men and women of excellence, women and men who are men and women of integrity and high moral probity. So you have 5 minutes to sell yourself within that context.
Thank you, Honorable Chief Justice. I will structure my introduction into 3 components. I will first give my professional competence, and I will also talk about my character, and then I will also talk about what I intend to do if I'm appointed judge of the High Court, about the backlog which you have mentioned. I have an LLB degree, an LLM degree obtained at the University of Nairobi. I am also a certified mediator. Concerning my work experience, I am a career public officer. I've worked for the government of Kenya for 29 years, save for only 3 months when I practiced as an advocate. I started off my career at the State Law Office, where I worked for 10 years as a litigation counsel, rising to the position of senior litigation counsel. I joined the judiciary as a pioneer legal researcher, and I researched for Court of Appeal judges alone for 4 years, developing my research skills at the Court of Appeal. And in 2013, I was appointed substantive deputy registrar of the Court of Appeal. And when the Court of Appeal was decentralized, I was subsequently posted to manage the Court of Appeal registries in Malindi and Mombasa, an assignment which I carried with devotion and excellence. In 2020, I was posted to Karsen Law Courts as Senior Principal Magistrate and Head of Station. I carried my work in Karsen competently, and I worked very hard there, but my career was unfortunately cut short when I was shot by Al-Shabaab militants together with my court staff, and also including the prosecutor, on our way back from Kipini Mobile Court. Thereafter, I was transferred to Milimani Commercial Court, a very busy court, and I worked hard in Milimani Commercial Court, and I delivered numerous rulings and judgments as the statistics would show. In Milimani, I also managed or coordinated the Mahakama Popote initiative, a very innovative initiative which is IT-based, where magistrates in other courts are able to share the workload in Milimani virtually. And the Chief Justice, recognizing my administrative skills and also my legal competency, appointed me to a committee to draft the Mahakama Popote rules, which rules we drafted and they were due for publishing when I left Milimani. Subsequently, I was also transferred to another very busy court, Makadara Law Courts. And my performance in Makadara Law Courts speaks for itself. 200%, 203. Out of my expected performance of 9%, I performed 18%. Chief Justice, I've heard you severally in this interview saying you are looking for a tractor. I believe I'm the tractor. I can lift, as shown by my record and my statistics. What does the High Court need? High Court needs hardworking people, men of integrity, impeccable integrity, which I am, and good character, honest, humble. I am humble. I handle litigants and advocates and accused persons before my court with dignity. And even those who come to my court will have admitted severally that I have handled them and they feel at ease with me. However, I am very firm. I'm independent and impartial in my decisions. I do not use my good cases to compromise any of my decisions. When I ascend to the High Court, if the Commission finds it fit to give me the job, I will do 4 things. Number 1, employing my registry skills, I will do a thorough case audit of the cases allocated to me, because one thing which I realized when I was in Milimani commissioners and Honorable Chief Justice is that as much as there is this backlog, there are so many cases which are spent within the system. So I will do a thorough case audit, and while engaging the stakeholders, I will ensure those cases which are dormant and which are spent are removed from the system. I will also, being a mediator, I am very passionate also about ADR. I will employ ADR in dispensing justice quickly. I will also root for substantive justice and avoid these many interlocutory applications. And I will deliver extempore judgments, rather no rulings, sorry for that, for applications which are easy and they can be dispensed without delaying the hearing. Finally, I am a very straightforward person. I am not corrupt. I can say that without fear of any contradiction. And I will be a crusader of anti-corruption, against corruption when I go to the High Court. Every court I go, the first day I always declare, to everyone I meet and to anyone who cares to hear that I do not entertain corruption. And that's the same thing I'll do when I go to the High Court. Thank you very much.
Thank you, Chief Justice. Your Honor, what is your understanding about a derivative action, and what conditions should be met before a court can grant leave for a person to proceed on the basis of a derivative action?
Derivative action, that one, I do not know that one.
Oh, okay.
Yeah.
Okay. Now, then, if a matter goes through trial,
Yes.
Before a high court or even before a magistrate's court,
Yes.
and the magistrate listens to the matter, both the evidence of the plaintiff or the defendant, and then delivers a judgment, and thereafter, at the point whereby the parties are executing a decree or the decree from the judgment, the defendant discovers that there was fraud, that the judgment was procured by fraud. What would be the cause of action for that defendant, and how would they go around it?
Okay, in the case of Lorian, which was a case in Nyeri,
Yes.
the court determined that a judgment in a land matter, that a judgment which is obtained by fraud should not stand. But once the judgment has been delivered,
Yes.
there's nothing much the defendant can do. What he can only do is to file another cause of action to impugn that judgment.
Yes, then you cannot say that there's nothing they cannot do.
Yes,
Yes,
as in
yes.
at the point of when the judgment has been delivered, in that particular judgment,
Yes.
he cannot, there's nothing much he can do. He will have to file another suit.
So he will file a suit and
Yes.
ask for what?
He will now ask that that judgment be declared a judgment which cannot stand and which is inoperative on the basis that it was procured by way of fraud.
And that will be through evidence? So
Yes.
it will be a suit?
Yes, it will be a suit, a different suit.
Okay.
Yeah.
Thank you, you are correct. Asante.
Thank you very much, Honorable Commissioner.
Thank you, Honorable Chair. Honorable Rotich, in criminal law, what constitutes a life sentence? A man who is 70 years old is sentenced to life imprisonment. A 23-year-old child, boy or girl, is sentenced to life imprisonment. What is that life imprisonment?
Life imprisonment, my lady, is not necessarily life in the sense that until somebody dies. There is a period which has been established by authorities that for somebody who is 70 years, if he is sentenced for another life imprisonment which is put at another 20 years or so, basically that man, even if he is released from prison, there's nothing much left of his life. So it does not necessarily mean life in the sense of he has to die while in prison.
So how long is a life imprisonment?
If I'm right, Honorable Judge, 50 years should be life. 50.
So 23-year-old, 70-year-old are both going to serve 50 years?
No, the one who is younger obviously will serve longer, given the age. And then the one who is older will serve a shorter
So
period.
is it unfair then, or is it discriminatory to have the one who is 23 years have a life imprisonment of 50 years, and the one who is 70 years not serve a sentence of 50 years?
I do not think it is discriminatory. It is about the practicality in it. Because if you sentence somebody who is 70 years to serve 50 years, it does not, it's not practical. So it's all about the practicality of that sentence.
Are you aware of any decisions emanating from our courts that have spoken to this issue?
I'm not aware of the particular decision, but I'm aware that issue of what constitutes life sentence has been litigated upon, and a decision has been made. I cannot remember on the top of my mind at the moment.
Do you know what decision was made?
That life sentence does not constitute the natural life in the sense of somebody has to serve in prison until they die. A certain number of years, which practically, for all intents and purposes, that person will, the other life which will be left, more or less, will not be productive.
Do you also know whether the Supreme Court has had an occasion to look at this issue and has given guidelines or a guideline as regards what needs to happen? As I have stated, I am not familiar, rather I need to check on the particular authority and maybe the guidelines. Yes, please read the authority of Julius Kisau Manyeso, where the Supreme Court corrected the Court of Appeal when it attempted to reduce that sentence to 40 years. And the Supreme Court, in my view, rightly said it is not the business of the court, but it is the business of Parliament to effect the necessary amendments, if at all. Now, so much as regards the technical question. I also wish to bring to your attention, Honorable Rotich, that there is a complaint that we received in respect of your candidature, and we made you aware of that complaint.
Yes.
And this was a complaint by one Edwin Washira on behalf of Dewdrop Enterprises Limited, and he says that he had a matter before your court and you found against him, and that in your response you actually admit, yes, that there was that matter, but this was an issue whereby this complainant was not satisfied with the outcome of your ruling, and he has since filed an appeal. Is that correct?
That's correct,
Yes.
My lady.
We've had an opportunity to look at it, and it is also our view that you're right in saying that he was challenging the merits or demerits of your ruling, and hence we have put this matter to rest.
Thank you, my lady.
Thank you
so much.
Honorable Chief Justice.
Thank you.
Thank you, Honorable Chief Justice, and Honorable Rotich. I must commend you for your zeal to serve the public. You are full of energy, and I think you'll do us good if you are successful to join the High Court.
Thank you very much, my lord.
Just one thing.
Thank you.
What is your understanding of the concept of separation of powers?
Concept of? Come again. Sorry.
The concept of separation of powers. How do you understand the concept of separation of powers?
The concept of separation of powers is that the three arms of government should discharge their respective mandates. The judiciary should be allowed to do its work.
What is its work?
To dispense justice and also to interpret the Constitution. On the other hand, the government also should be allowed to do its executive, to discharge its executive mandate of running the day-to-day affairs of the government, of the executive. And on the other hand, Parliament should do its work of making laws. However, this separation is not entirely practical. Apart from that, whereas that separation exists, the three arms of government also work together on areas which are common to them to serve the citizens of the country. So it is there. I mean, all the three arms of government should respect their different mandates, and none of the other should interfere with the other in the discharge of their duty. Everyone should perform their functions. So that's basically what I understand about in respect to the concept of separation of powers.
Okay. So,
Yes.
Taking you back to the discussion you had with Judge Commissioner,
Yes.
Parliament passes a law that says if you're guilty of offense A, the sentence is death or is life imprisonment. Judiciary comes up and says, despite that law, in upholding human rights and going through the international instruments and all this, the sentence of life, that this life imprisonment, shall mean a certain term. This is judiciary, not parliament. Would you consider that as an overreach by judiciary into legislature?
I would not.
You will not?
I would not, because once the judiciary has discharged its mandate and rendered itself in the best understanding and application of the principles, including international law principles, then the judiciary has done its work. So it's up to Parliament to make a decision on what to do about what the judiciary has stated or has declared.
Okay, so do you think there are any instances where the judiciary can overreach into their arms?
Where judiciary can overreach is where judiciary now.
Sorry, it's off. I don't know what has
Sorry, judiciary goes into the realm of making decisions, and which in effect would be like performing executive function. The judiciary, I believe, they should be free to render their position, their legal position, to the best understanding, applying all the principles. But then, what judiciary should not do is to make executive decisions or direct executive decisions.
Okay, thank you. I wish you the very best, Honorable.
Thank you.
Good morning.
Good morning, Honorable AG.
Now, the Constitution of Kenya provides that the High Court has unlimited jurisdiction in criminal and civil matters.
Yes.
This jurisdiction sometimes is comprised within a term referred to as inherent jurisdiction. What do you understand by the term inherent jurisdiction?
Inherent jurisdiction is that jurisdiction which is in the court, even if there are no particular legal provisions to make the court operate. It is what constitutes the court in terms of its functions and its being. So even if there was no, the law does not cover all issues and all everything that happens in court. So inherent jurisdiction is that jurisdiction which is in the court to do that which is lawful and to do that which will facilitate the dispensation of justice as a court.
Now, further to that,
Yes.
it also has residual powers.
Yes.
What do you understand by that?
Residual powers, I think, would mean that when everything else has been done, all else has been done, and then there's something, there's some directions which need to be given, and the court has residual powers to make directions on what should be done.
Now, section, I think 18 or 17, section 18 of the Civil Procedure Act,
Yes.
provides guidelines on when and how a high court can transfer a matter from one court to the other. What powers has the High Court to transfer a matter from one court to another?
Honorable Attorney General, do you mean the High Court transferring a matter from one High Court to another High Court?
I'm putting it to you. What you make of it is your call.
All right. Thank you, Honorable Attorney General, for that.
Are you familiar with Section 18 of the Civil Procedure Act?
Yes.
When can a High Court transfer a matter from one court to the other?
When, for instance, in respect to where a matter is an ELC matter, and the court finds that this is not a High Court matter, I believe the High Court has jurisdiction to transfer the matter to the relevant court. And also the High Court can transfer a matter from one High Court to another High Court, and also from one court to another. The lower courts have no powers to transfer a matter from one magistrate court.
My question was
Yes.
High Court.
Yes, yes.
When can a High Court transfer a matter from one court to another court, and which courts? Pursuant to Section 18 of the Civil Procedure Act.
Where a matter, for instance, is filed in let's say Machakos, and the matter, another High Court, I mean, the matter relates to an issue which the cause of action arose in Nairobi, geographically. So the High Court has jurisdiction to transfer a matter to be heard in a court which has jurisdiction geographically to handle the matter.
Okay, let's help ourselves out of this.
Yes.
Section 18 of the Civil Procedure Act provides that a High Court can transfer a matter to a subordinate court. Where do you get the provisions where a High Court can transfer a matter to another High Court?
The High Court Administration Act.
Section?
Well, I cannot point out the right section at the moment, but there is this practice where a party would file a matter which entirely relates to a matter which happened in Nairobi. So administratively, the High Court can order that matter, so that to avoid the issue of forum shopping, could be transferred to a court within the location where that matter ought to be heard.
Can the High Court use or invoke inherent jurisdiction to confer jurisdiction to another court other than the High Court?
Yes, the High Court, as you have rightly pointed out, Honorable AG, has jurisdiction to transfer matters to lower courts which have jurisdiction.
No, that one is provided for under the Civil Procedure Act.
Yes.
That a High Court can transfer a matter to a subordinate court.
Yes.
My question is,
Yes.
can the High Court use inherent powers or jurisdiction
Yes.
to transfer a matter from one High Court to another?
Yes. Yes, it can.
Are there provisions in our law allowing the High Court or giving power to the High Court to transfer matter from one High Court to another, or a court of equal jurisdiction to the High Court?
As you have rightly pointed out, Honorable Attorney General, the inherent of the jurisdiction of the court to facilitate dispensation of justice and proper administration of justice can transfer a court which is which ought to hear the matter and where the matter arises for convenience and that to facilitate.
Okay,
the
let's
administration of
finish this.
justice.
Let's agree first.
Yes.
We are understanding each other.
Yes.
Is there a law that allows the High Court to transfer matter from one High Court to another? Having agreed that there is a law under the Civil Procedure Act giving power to the High Court to transfer matter from the High Court to a subordinate court, is there a provision of law that gives power to the High Court to transfer a matter from one High Court to another High Court or a court of equal jurisdictional status?
Well, I cannot cite the law immediately, but I agree with you, Honorable Attorney General, that then the court may then, exercising its inherent jurisdiction, transfer a matter to another High Court. But I'm aware that the High Court Administration Act makes provisions that a matter should be heard where the cause of action arose geographically.
Okay, recently the High Court has pronounced itself over the validity of using inherent powers to transfer matter from the High Court to a court of equal jurisdiction, in which case it was referring to Environment Court, Land and Environment Court, and the Labor Court. Do you remember any authority on that?
I do not remember any authority, but I'm aware that where a matter has been filed in the High Court.
No, I just asked you for the authority.
No, I have not.
So after this, I think you can show me the legal provision, the one you are referring to, where a High Court can transfer a matter under the law to another High Court.
I'll check that.
Thank you.
Thank you very much.
Thank you, Chair. Good morning once again, Your Honor.
Good morning, Honorable Commissioner.
You need some water, or we?
Yeah, let me take some. Thank you. We can proceed.
You did submit to us decisions you have done in civil, commercial, and criminal matters. They demonstrate strong command of procedural and substantive law across the areas I've just cited. They are well structured. You're able to clearly identify issues, and you sequence your analysis carefully. The decisions, as I've read, they emphasize due process, structured legal reasoning, judicial restraint, and you avoid speculative conclusions of overreach. The tone throughout is calm, impartial, and professionally restrained. So I commend you for that. My question is, since the promulgation of the current constitution, the scope of judicial review in Kenya has evolved, particularly with enactment of a law and jurisprudence from the Court of Appeal. Are you aware of those changes? If yes, kindly explain.
I'm aware of the changes. Previously, before 2010, judicial review was anchored in the Civil Procedure Act and Law Reform Act. But with the promulgation of the new constitution, now judicial review has constitutional underpinnings in Article 47 of the Constitution, and it provides that right to fair administrative action should be expedient, should be efficient, lawful, and procedurally fair. In the new constitutional dispensation, judicial review is now more robust, and because of the new ingredients which are captured both in the Constitution and the Fair Administrative Actions Act. Now, the courts have found that actually, apart from looking at the procedure, judicial review has now extended to looking into the merits of a particular administrative decision. The grounds for judicial review have also been expanded. Initially, they were just, the judicial review was founded on whether a matter was ultra vires, whether a decision was ultra vires, whether the parties were given a fair hearing, whether there was natural justice. But now, judicial review in its expanded and enhanced position, now there are new grounds like legitimate expectation and proportionality, which have been and reasonableness, which have now come into play because of the new constitution and because of the act. So it has been expanded. They are merit based. It's merit based, and apart from just issuing the traditional orders of certiorari, mandamus, and prohibition, now even the courts through judicial review can issue structural interdicts to direct the government to carry out some actions which are lawful and which make citizens to enjoy some rights to implement within some certain period of time. So it is more robust, more enhanced, and it can also apply now. Judicial review now even applies to private entities performing government functions. So it's enhanced and more robust.
Okay, I'm okay with that, and I wish you the very best.
Thank you, Honorable Commissioner.
Yes, the Supreme Court has laid out a 9-point test to assess whether public participation has taken place or not. What are the 9 points?
Okay. Public participation should be real, should not be cosmetic. The parties should be given a notice. The public participation should be such that parties, rather the citizens, are able to influence the decision. They should be given notice of where the meetings will be done. But the Supreme Court has also found that public participation does not have to be only oral. It can also be by way of written submissions. It can be done by way of written submissions. I don't know how many have I.
Okay, those are
okay.
enough.
And I will quote the case of the BPI case.
Okay.
And the British American tobacco case.
Okay.
Yes.
So assuming Parliament the National Assembly
yes.
has a bill before it,
yes,
and it calls for public participation, and people give their views, is that the end of public participation for that bill?
I didn't get it again.
The National Assembly,
yes,
it has a bill before it.
A bill, yes.
They then call for public views from the public on the bill. The bill is going through certain stages. Is that notice inviting public views, is it sufficient?
I do not think it's sufficient. There are other levels of public participation which can still be called.
When? At what point?
Once I believe once the Parliament has debated the bill,
Yes.
I don't know, I'm not very quite sure, but at some point, I don't know, before the third reading or something, they also went at the committee stage.
Yes.
The committee also can call for public participation now to...
So this notice I'm saying
Yes.
that goes out to the public is at the committee stage.
Yes.
Does Parliament have to do any further public participation after that?
After issuing the first notice,
After the committee receives views from the public, does Parliament need to do any more public participation on that bill?
no, I do not think.
Okay, thank you very much.
Thank you very much.
What if Parliament amends? The bill has been presented to the people for public participation, and then in the second and third reading they make substantive amendments to what was presented to the public.
If Parliament introduces new amendments and what was not there before at the initial stage of the bill,
Yes.
then it will require public participation, because it will mean that now these are new laws which have come up, new substantive amendment which have come up. So I think the public are entitled to be heard.
But does Parliament have a latitude to make those amendments based even on the views from the public?
Based on the views of the public,
Yes.
yes.
And then if they made that amendment, would there be a need for them to go back to the public?
If they make the amendments based on the views of the public, then there would be no need to go back.
Okay.
But now if they introduce their own amendments, which there's been no public participation, then I think it will be like introducing new things, which I think it will not fit into the test of public participation.
All right, thank you.
Thank you, Chair. Good morning once again, Mheshimiwa.
Good morning, Honorable Commissioner.
I just want to have a brief engagement with you concerning your performance from the report I have from DISPOP. I don't know if you were given a copy.
Yes, I was given a copy and I looked at it.
Is it accurate?
Yes, it is.
It is accurate, okay. Yeah, as you said earlier in your introductory remarks, indeed you are carrying more than your expected weight at the rate of 202%. What is expected of you is 9%, you are carrying 18%. That is commendable. I commend you for that. I also note that your backlog situation at Makadara is not so bad. I've done the math. You have only 12% of your cases are backlog. So about 88% of your cases are current. I think that is also good. Your court productivity is also quite good at 696 against the national average of 370. But where there is concern is your case clearance rate, which is lower than the national average by far. You are at 80%, the national average is at 104%. I don't know what the challenge could be, and also maybe you can share with us what you are doing at Makadara to enhance the case clearance rate.
Makadara is a very basic court, Honorable Commissioner, and there is a very high volume of cases.
Mm-hmm.
You finish a set of cases this week, another set, which if it's not more, comes next. So it's because of the petty cases.
Mm-hmm.
One of the biggest problem I've seen in Makadara is the infrastructure. That court is very small to serve the population it serves. Like Milimani, where I worked, the number of magistrates are, I understand they are now about 27. Whereas Makadara, which serves the whole of Eastlands and does so many criminal cases, only has 10 magistrates. But I understand the challenge, because it's a challenge of infrastructure. So once we have more magistrates, we will be able to achieve that case clearance rate and even surpass the national average. As you've seen, we are working, but then our numbers cannot allow us to achieve a high case clearance, because cases keep coming, new cases every time. there is a very high turnover of new cases being filed on day-to-day basis.
Incidentally, I also worked in Makadara, and I agree with you. A lot of cases, I think you serve about 40 police stations.
Yes, 42 actually.
42 police stations.
Yes.
And as you say, a lot of them are petty cases. And I appreciate that the numbers are low, and I know for us to get to, it will be a long time coming before we have optimal numbers on deck. But as at now, what are you doing, especially now that you mentioned that a good number of your cases are petty cases? What are the interventions you're putting in place to make sure that there's a high turnover of these cases as well? As they come in, you're able to clear them faster and dispose of them.
The interventions we are putting in place, let me just say this before I come to the interventions. Most of these petty cases, invariably, most of them plead guilty. So you are able to dispense with them. What can we do ourselves? We just
For instance, okay, let's say 50% of them, or maybe 60% of them, petty cases have pleaded guilty. What even 60s? Let's say even 70% have pleaded guilty. You have 30% remaining that have pleaded not guilty. What can you do about those 30%, especially in petty cases? What are you doing?
Okay, my experience in Makadara is that really even those who do not plead guilty, rarely to petty cases advance and to become full hearing and full judgments. So in the course of time, we employ reconciliation, and we bring parties to talk and agree. And in the course of time, many fall by the wayside. So it's just encouraging the multi-door approach in dispensing those petty cases, and it works because many of them actually reconcile. Many do plea packing, and they fall by the wayside.
Okay, thank you, and I wish you well.
Thank you very much, Commissioner.
Thank you, Honorable Chair, and welcome again, Mheshimiwa. Now, could you name to us the legal framework that governs leadership and integrity?
First is the Constitution. Then there is Leadership and Integrity Act. There is also Anti-Corruption and Economic Crimes Act. There is Ethics and Anti-Corruption Act. There is Conflict of Interest Act. All these statutes provide the legal framework for enforcing the imperatives, constitutional imperative in the Leadership and Integrity Act. Particularly the Conflict of the Conflict of Interest Act, which replaced the Public Officers Ethics Bill. They directly speak into those imperatives and how they should be upheld and enforced.
Okay.
Yes.
Could you also explain to us the guiding principles in leadership and integrity? And just tell us also how you have applied them. You started by saying that you're a person of integrity.
Yes, I am.
Now tell us how you have observed the leadership and integrity principles espoused in Chapter 6 of the Constitution.
One is objectivity and impartiality. In delivering my judgments, as I've stated before, I'm very objective. I may be friendly, but very objective and impartial. The other one is selfless service. I have demonstrated that I have worked hard. I have served the government for 30 years, close to 30 years. I have worked in a place where I almost died when I was in the course of duty. So that demonstrates the spirit in me, which demonstrates my implementation of these principles of leadership and integrity. I'm also disciplined and committed to the delivery of service to the public. And there's also another one which says that service which is purely based on the interest to deliver services to the public without my own interests. When I report to work, I'm very open-minded. I just go to work to work, and in the evening I go home. I have no interest in any case where I work. So I do my work purposely to serve the public and nothing else.
Very well, Mheshimiwa. Now, in these many years of service,
Yes.
could you just share with us an instance where your integrity was tested, one that really, really bothered you, and just tell us how you went about it?
When my integrity was tested.
Yes.
I can tell you, people fear me. I tell everybody around, I am saved. I do not take bribes. So I have not had occasion really to because people know my stand, and I've rarely confronted any situation where somebody comes to. Of course, friends are there, and they will talk to you, and they will bring their issues, but you keep your stand, and you keep things professional, and you don't want to compromise your work.
Very well. I wish you all the best.
Thank you.
Thank you, Honorable CJ. Good morning once again.
Good morning, Honorable Commissioner.
I only have one question, and
Yes.
it's centered around the feedback we received from the public.
Yes.
They had some good things to say about you and your leadership
Yes.
in Makadara in the
Thank you.
dispensation of justice. But then there were also areas of concern, and the biggest area of concern was your poor planning. They seem to say that your lack of planning causes delays, and then sometimes you also lose control of your court. There were also issues raised about pending judgments in Milimani, though this one you responded to. So let's focus about your planning and the things that have been raised, that you lose control of over your court, and you cause delays because of the confusion. Sometimes you give contradicting days for the same matter.
I didn't get the last sentence, Honorable Commissioner.
Sometimes you give contradicting dates for the same matter. You give 2 dates for one matter because of planning. That is feedback from the public, so maybe you can explain yourself.
Well, I suppose most of these feedbacks have come from Milimani. That's what I guess. But I have since okay. Let me give a bit of my background. I was so much into administration, and but I've since been able to know how to manage court process. I'm able now to deliver my judgments very well. And I manage the court process very well, and that is demonstrated by my results. There's no way you can be able to deliver if you do not manage. So in my view, those comments may not be quite fair, because I have performed. I have done 9%, rather 18 instead of 9, 202%. There's no way you can be able to perform if you do not manage your time, manage your court, manage the court process, and at the same time deliver. I believe I manage the court very well. I do my work. I work very hard, and maybe just one weakness that probably I could have had, but I've corrected. And I learned that when I was in Makadara. I was advised by my court officers that, please, this work is a lot. So you have to limit the time you give to accused persons, the audience you give to them. Because of the way I'm wired, I always like listening to people's problems. So they told me, mitigation, don't take a lot of time with them. So I've since changed. I am more formal, and I do not give a lot of time. So I've managed probably the time I give to accused persons to address the court, to mitigate. And that way, I'm able to move faster. So, and that's something which I realized and I've changed.
Okay, how long have you been in Makadara?
I've been in Makadara for 1 year.
Okay, all right. Actually, that bit of you're very calm and patient with parties in court, maybe it's also been said here, but yes, in a different way. They've said that during virtual proceedings, you seem to lose focus because of that element of patience. So
yes,
maybe it's an area that you need to work on. And then also, one thing I picked from this is your integrity. The way they talked about your integrity is exactly the same way you've described yourself, so keep up the good work. I wish you well. Thank you.
Thank you.
Yes, good afternoon, Your Honor.
Good afternoon, Honorable Commissioner Vice Chair.
Umechoka, or are you still okay?
No, I'm strong. I'm used to this in court.
Okay. Fine. Give us your perspective of judicial independence and why it is important.
Judicial independence is provided for in, I believe, Article 160 of the Constitution, that no one should direct judicial officers, judges, and even staff in the performance of their duties. And I think this is important because judicial officers and judges and even those who are supporting them should do their work based only on the law and the facts presented. However, in matters of administration, we cannot say we are entirely independent. We are subject to the government procedures. We are subject to audit. So that's independence only is applied with regard to our work, our core work of delivering justice. So there has to be that balance, that we work with other government institutions in matters of administration, but in terms of our judicial work, we should be totally independent.
From your experience,
yes,
what do you consider to be the single most challenging issue that the judiciary is faced with today? And how would you address it if you are appointed?
The single most pressing issue which judiciary is facing today is backlog. And as I stated in my introduction, once I am appointed, I will be able to do first case audit. I believe there are so many cases in the system which ought to be disposed, because the course of action has shifted. The course of action is spent. So once there is continuous case audit, and with the involvement of stakeholders, we will be able to reduce backlog of cases. Also, that backlog of cases is also tied with finances. We can only deal with backlog as judiciary when we have resources, enough resources to construct courts, to employ more judicial officers, and I'm glad, and judges, which exercise the Commission is undertaking. And that will only happen when we have resources. So we need resources so that we will be able to tackle the problem of backlog.
Thank you.
Thank you very much, Commissioners, and also Honorable Rotich. I also worked with you, and alongside Justice Ishale. I think if we were asked to describe you, for me, I would say you are for the light, because every time we asked you for this or the other as the Deputy Registrar, you said there was no money. So your standard answer was there was no money. That's how we would describe you. Yes, but thank you very much. That was on a right note. This brings us to the end of this interaction with you this morning. Before we release a candidate, we always give them an opportunity also to engage us. So you have the floor.
Thank you so much, Honorable Chief Justice and Commissioners. Not once, not twice, I've appeared. This is my third time. So I pray that this one bears fruit.
We recently promoted you to Chief Magistrate. God just has to be grateful even for small things.
Yes, Honorable Chief Justice. But as I explained to the Commission when in my interview as a Chief Magistrate, I explained that I have served for so many years as Deputy Registrar of the Court of Appeal, which position I'm very grateful. I am extremely grateful. But then the level which I served was more or less at par with the position of Chief Magistrate. In fact, when I went back after the promotion, there was not much drastic change. But I appreciate the promotion, and I'm very grateful even for the opportunity to be heard. And I have served for 30 years, close 29, 30 years. I think time is ripe for me, God willing, to ascend into judgeship. But of course, you make your independent whatever decision, and I'm just praying, and I'm trusting God. So thank you very much. Just as a matter of feedback, I will go back to the Milimani Court and the Makadara courts, the busiest courts in the country. For someone to work in that court, you cannot. There's no way. You cannot. You have to be hardworking. You have to work. There's no. You cannot make it. So I can tell you, I am very hardworking, and I've worked. I may be having some challenges, but I've worked hard, and so that one is there's no doubt. And also the magistrates who are working there, they work under very difficult conditions, and they work very, very hard. So they need a lot of support. They need a lot of encouragement.
Thank you.
Thank you very much. I wish you God's blessings in your deliberations and God's wisdom. Thank you very much, and thank you for the opportunity. Thank you. God bless you.
Thank you. We appreciate your views, and the commissioners have heard about the state of affairs in Makandara. We are constantly trying to see how we can give some remedies there to help with the congestion. I think on behalf of the Commission, we wish you success. We wish you all the best. We will get in touch with you when we complete the exercise. But meanwhile, as we encourage all the candidates who appear here to continue doing a good job in whatever capacity God has put you there. So all the best. You are released.
Thank you very much.
Yes.